try to explain what the Supreme Court is trying to achieve here or takes issue with.
Well, the case is called State versus Blake, and it was decided this morning by the Washington State Supreme Court. And the court is, in a very unusual step, ruling a criminal statute unconstitutional and saying that it violates the legislature's police powers. At issue is the question of whether a person possessing controlled substances, possessing drugs, is required to prove that they intended to possess those drugs. Now, this is a pretty common situation in a drug arrest, but the court is saying without proof of intent, and with the statute doesn't require it, then the statute is unconstitutional. So what's happening is any sort of innocent possession of drug prosecutions, convictions, sentences in the past are in jeopardy.
And so would these have to be cases in your mind where the defendant did claim at the onset, be it, 2 years ago, 3 years ago, 5, whatever years ago, that, oh, this isn't mine? Would they have had to make that claim originally for this to be relevant to that case?
In all likelihood, yes. The question of whether this pretty remarkable decision applies to prior convictions will be up to the court in the future to decide. And essentially the court's going to say, look, do we have cases in which persons have gone to jail for a longer period of time or in jail only because they innocently, passively, and unknowingly possess drugs? And if that's the case, then you'll find a number of cases being attempted anyway to be reopened around the state that involve convictions for, in essence, unknowing possession of drugs.
That being said, if you have a case where either they didn't dispute that the drugs were theirs, or there's pretty strong evidence, like a buy bust, for instance, where they're on camera or they sold to an undercover police officer, would those be cases that probably would hold up?
Yes, I would think so. I would think that those cases, because the state's in a position to and probably did prove intent. I would think that an individual challenging a prior conviction would have to say, I attempted to make that claim in my earlier trial, and the court found I was not successful. What's happening now is the Supreme Court has shifted this burden back to the state. The state must prove intent in order for a criminal statute like this to be acceptable. And for now, the court seems to have thrown out the entire statute.
So that, I think, there are people who are going to have a strong reaction to this, but at the same time, we're always taught that innocent until proven guilty. The burden is on the prosecution, not the defendant. Why in drug possession cases is it flip-flopped?
Well, really, Washington State is something of an outlier in this regard, that the strict liability of possession of drugs, that somebody could really be telling the truth, that they did not know that drugs were in their apartment, that sort of thing. And so it is unusual because the criminal law normally requires that the state prove that a person intended to engage in this conduct. So a strict liability criminal law is unusual. What I think this is reflecting is changing drug policy. The legislature itself, as you know, is considering a law to change the criminal penalties for simple possession of drugs. And it may be that the Washington State Supreme Court has got out a little bit ahead of the legislature.
One of the questions I'm going to get is, well, then what would stop, down the road from it being a slippery slope, somebody to say, well, that gun isn't mine. This bloody knife isn't mine. I didn't know that this was a stolen vehicle. So can you make that equivalence, or is that just totally apples to oranges?
Well, if we just keep it to passive, unknowing conduct, it's not likely that you're going to be wrapping this up in very many circumstances, because strict liability in criminal cases is very rare. There are only a few of them. Certain rape crimes, for example, child rape crimes. Other very few crimes are what we call strict liability, where the state does not prove intent. So that part has always been unusual. And in a way, this decision corrects that. Some may question whether it's the court that should be correcting it or whether the legislature should have done so, but the decision is binding now, and that's the law of the state of Washington.
So just so I'm clear, because I think it's a comparison that could help people understand. When it comes to child rape, for instance, the idea being that it's not an excuse to say, I didn't know that this person was underage.
Right, exactly. Exactly. The law is saying you can't claim I didn't know that this conduct was illegal. What the court is saying today is different about this is that the state should bear the burden of proving this intent with very few exceptions, and that the passive, unknowing, unintentional possession of drugs, if those are in fact the case, cannot meet the requirements, the due process requirements of the state and federal constitutions, and is therefore invalid. It's quite a decision.